It's actually also common practice to count unvested time-based RSUs. And I'd say probably 3/4 of companies count unvested time-based RSUs. What's the rationale for this, right? RSUs, I guess the viewpoint is that they're going to be earned regardless of stock performance of the company. Essentially, if executive remains in the role and until the end of the vesting period, then they're going to receive the RSU grant. So no issues with counting that in the ownership guidelines when the award is granted versus when it vests. And if you look at externally, ISS, Glass Lewis, the proxy advisory firms, they don't have an issue with this approach either. So again, common market practice, but there is a word of caution here as well, right? Some companies, if we think about their LTI mix, they grant a significant portion of equity in time-based RSUs. Upwards of 50% of an LTI program could be time-based RSUs. And if you're counting that for the ownership guideline, this is often measured pre-tax, right? The RSUs haven't been taxed yet because they haven't vested yet. And if you're comparing that to the rest of the equity or the stock that are included in the stock ownership guideline calculation, that is post-tax holdings, right? So often shares are withheld at vest to cover the taxes. So it could be up to half of the value that was granted. And because of this, there's that potential that an unvested RSU actually has an outsized percentage of the value of the stock ownership guideline.